Good afternoon, everybody. I am Jenny Jeffress. I'm the Executive Director of the Madison Public Library Foundation, and welcome to our webinar. I'm so glad you joined us here today. We have a great panel of presenters today to learn about estate planning at any age, and I hope you're ready to take a lot of notes. But we will also be sending out the presentation. So I want you to know you can take a lot of notes, but we'll be sharing it with you as well. So that you can kind of enjoy and participate in the conversation with our presenters today. So the Library Foundation has been hosting these educational workshops for a number of years. Pre-COVID, we had them in person at the Central Library. And during COVID, we went to virtual programs, and those have worked out really well. And we feel like we attract a really nice audience of people by continuing to do these virtual programs. So we typically do about 3 or 4 a year, and we're delighted that you have joined us today for this presentation. We are also recording this, so if for some reason the doorbell rings and you have to go get something, we will send it out to everybody who's signed up so that you will get a copy of this presentation for later time use as well. So one of the main reasons we put on these workshops is because we at the foundation want our donors to feel really informed about a lot of educational topics, but we also want you to feel informed about estate planning and planned giving. And this workshop here today is particularly themed to that event, and we have great experts from our Madison community who are set to talk to you. So we put together these workshops because we have volunteers. So our panelists are volunteering their time with us today, and we have a committee of volunteers that help us organize these events as well. And we couldn't do this without their support and their energy and effort on our behalf at the library. So I'm going to start by introducing our moderator here today, and she's going to kick off our panel discussion. So thank you for coming. But I'm going to introduce now Andrea Hsu. She is the Development Program Director at Wisconsin Foundation and Alumni Association. And Andrea has been a volunteer with us for a number of years. And I think uses our Penny Library on the East Side on a regular basis. So I'm happy to let Andrea take it away as our volunteer moderator, and she will get us going with our panel.
Actually, you can find me at Sequoia generally these days, but growing up, I was a Penny user. So I've been a lifelong Madison Public Library fan. And
well, I'll see you at Sequoia. That's my neighborhood library too.
I'll see you there. Thanks so much, everybody, for being here today. Welcome. We are honored to be joined today by 3 presenters. Johanna Allex is a partner in the Madison office of Stafford Rosenbaum, where she helps families and individuals plan for and manage life's expected and unexpected transitions. Johanna's law practice covers all aspects of estate planning and estate administration, marital property law, business succession planning, tax-exempt organization planning and operations, and alternative dispute resolutions. Rachel Snyder is a senior associate in Stafford Rosenbaum's Madison office with practice focusing on trusts and estates, nonprofit law, and administrative law. Rachel believes in providing families and individuals with the best tools and information to plan for their life circumstances, and she frequently presents on estate planning for different organizations and groups. Finally, Danielle Becker is an associate at Stafford Rosenbaum with a practice focused on trusts and estates. She has experience with counseling clients, colleagues, and financial professionals through all phases of trust and estates work, including estate planning, probate, trust settlement, elder law, special needs planning, guardianships, and real estate. So you're going to learn a lot here today. Without further ado, I'll hand it off to the team at Stafford Rosenbaum.
Thank you, Andrea. I really appreciate this. And thank you all for inviting us to come speak with you. As Andrea said, we're attorneys with Stafford Rosenbaum, which is a law firm here started in Madison in 1879. And we're located on the same square block that the downtown public library is located in. In fact, you can see the roof from my office window. And we also have an office in Milwaukee that started about 15 years ago. So between the two, we've got good coverage for most people's needs. So I'll be talking with Rachel and with Danielle today about estate planning. It's a fairly basic class. Getting started at any age is the title. And hopefully, if you have an estate plan, you may learn something new or something additional that you want to do with your estate plan, or if you don't have one, hopefully we'll help you to gather enough knowledge to get started and feel more comfortable through the process. So our presentation will cover essentially the who, what, where, why, and hows of estate planning. Why to get started, when to get started, and then also why and how to include charitable giving as part of your plan. And then we'll give you some tips for getting started and also some ideas about what to expect from the estate planning process, so it's not just a big question mark in your mind. So I like to think of estate planning as really building a safety net to help you manage the transitions. The who in the estate planning question is primarily you, estate planning for yourself, but it's also estate planning for the people that you're asking to help out during those transitions, because to the extent that you put together a plan, your plan will give them tools, perhaps even more tools, definitely more tools than they would have if you didn't have a plan. And also with this plan, you get to decide the extent of your safety net and the type of safety net that you have. So generally estate planning, like I said, it's focusing on helping to manage the transitions, but there's two general points in time. One is if you become disabled, and two, after your death. So for the estate planning, so that, or the plan, so that it is organized in a way that you would like, you'll need to think about who you would want to appoint in the various responsible roles, what type of plan you would like, where should the various aspects of your plan take place, when should the plan take place, and how should it take place, and why. Now, really, the who's are something that you can control and start thinking of before you meet with the attorney, but the attorney's job is there to help you with the what, where, when, how, and whys. In addition to building a safety net, an estate plan helps you minimize reliance on the default rules in the law. As you can imagine, these transitions without any plan in place, they can create just a standstill until somebody's appointed to make your decisions for you if you can't, a standstill to appoint somebody to distribute your property after you die, if you haven't already appointed, a standstill to figure out what happens with that property after you die. So your plan is designed to minimize reliance, because those default rules take time and are often much more costly than if you had done the planning in the first place. And the size of your estate should not be a determining factor as to whether or not you do an estate plan, because as I mentioned, it's really about helping to build a safety net to manage those transitions that happen to all of us. And sometimes the size of the estate will drive what types of tools you put in into your estate, or what types of tools are put into your estate. But generally the appointment, the various responsible roles, the need for those responsible roles really applies to everyone. And so in terms of when, well, now is the right time to start. I mean, not right now, we'd like you to stay and listen to our class today, but now I wouldn't put it off, don't wait. And the reason being is that transitions can happen to anyone at any time. And it's good to have a safety net, even if you need to change it. We'll be talking about when to review and what types of things or circumstances would suggest that the time is right to review and perhaps update, but now is the right time to start. And don't feel badly if you haven't started. You've got lots and lots of company. Or if you're sitting with an estate plan that's 25 or 30 years old, don't feel badly. Now's the time, and it's good to get started. So then the other thing about the who, one more point, is that estate planning is generally done for yourself and for the people that you're asking to help you manage those transitions, but you also may know somebody or would be the likely candidate to be asked for help if somebody you know runs into difficulties. So it may be that you have somebody in your life, a partner, a child, a neighbor, where an estate plan would be great because it will allow you and enable you, provide you with the tools to get started to helping them without having to rely on the default rules.
Excuse me, as Johanna said, there are a lot of different tools that can be used to create an estate plan. And commonly, the place everyone starts is with a will. So what is a will? At its most basic form, a will is a legal document that coordinates distribution of your real and personal property at death. But do you need one? So when you start thinking about whether you need a will, it's important to start evaluating the kinds of property that you have and understanding that there is this concept called probate, which you may have heard, or maybe not, but in general, probate is a court supervised process that determines the validity of a will, and it controls distribution of your property subject to the terms of a will. But not all property is subject to probate. So things that are subject to probate are things that can't be titled. So your books, your jewelry, your artwork, things like that, and items that are titled only in your name. So they're not shared with someone else in terms of ownership. Property that isn't subject to probate are things that generally have beneficiary designations or some other kind of contractual arrangement that controls how it's distributed after your death. So retirement accounts, life insurance accounts, property that's titled in your name and in someone else's, especially if you're married and you own real estate as survivorship marital property. This also gets to one of the questions that we received in advance, which was about TOD designations. So, excuse me, a TOD designation stands for transfer on death. It's like a beneficiary designation, and it would control over the terms of a will. So as we'll get to later, when you have a plan, it's important to make sure that all of your beneficiary designations are aligned with the terms of your will so that everything works together and ultimately is distributed the way that you want. And then another thing to keep in mind in Wisconsin is that there is a difference between marital property and individual property. Wisconsin's a marital property state, which generally means that spouses have an undivided 1/2 interest in property that is acquired after marriage. But it's very easy to start commingling assets that you had maybe before marriage with assets acquired after, and to sort of blur the lines and effectively turn everything that was individual property into marital. And that matters when it comes to property distribution. So things to keep in mind include whether you want to develop a marital property agreement that classifies property as marital or individual. There is also a mechanism in a marital property agreement that is called a Washington will provision, which is effectively a backup tool for distributing property to your spouse or to a trust if you have one, in case something is left out. But essentially, keeping in mind all of the different kinds of property that you have and how it's owned will feed into your choices about what kinds of tools you use to develop your total estate plan. So in terms of a will does have some advantages. It allows you to break from the default rules that Johanna mentioned. Those default rules are just contained in Wisconsin law, and setting up a will allows you to differ from those and to dictate what happens to your property in accordance with your wishes. Setting up a will also allows you to name the person or the people who will be responsible for seeing that your wishes are fulfilled. In your will, that is done by identifying a personal representative. That term is how Wisconsin identifies executor. So if you hear executor, here in Wisconsin, we call it a personal representative, but it's functionally the same thing. And then setting up a will also allows you to identify a person or people, succession of people that you would like to serve as guardian if you have any minor children. So setting up that will can be very important for addressing your wishes and making sure that people that you trust are set up to fulfill those wishes. Also important to keep in mind are if you have any unique family circumstances. So you may wish to distribute your property in a way that isn't contemplated by the default rules. So asking yourself questions like those on your screen are important. Do you have a unique family situation? Are you in a second marriage? Do you have children from the first marriage? Do you want to ensure that those children inherit from you in a particular way? Do you want to give to charity? If you were to pass and you still have minor children, would you want your assets to be held in trust for them until they reach a certain age? Perhaps they're too young to handle whatever you would be passing to them, and you'd like someone else, a trustee, to manage the money for a while and to make sure that it's being used to support their health or their education in a way they perhaps may not do if left to manage it on their own. Do you want to provide for grandchildren? It's important to consider all of your life circumstances and to identify your priorities and your interests by asking yourself questions like these, because these are the things that a will or a trust can be set up to accomplish for you. So, transitioning here to the concept of a trust, commonly estate plans are based on revocable living trusts. But a trust in general, it's a contractual arrangement between a person establishing the trust and a person who's legally authorized to manage the trust property. And it sets forth powers and duties of the trustee, and it designates beneficiaries. So as I said, in estate planning, we commonly use a revocable living trust. And typically in that situation, the person who's setting it up, so you, for example, you are the grantor who's setting up the trust, and you're serving as your own trustee. And you then have the power to amend the trust, to revoke the trust down the road if it no longer suits your purposes. You may hear other kinds of trusts. There are many kinds of trusts that are available for use in estate planning. But for purposes of the conversation today, we're going to stick with focusing on this concept of the revocable living trust. So it's common for very high net worth individuals to use trusts for tax planning purposes, but trusts do offer advantages even if your estate is not so significant that it triggers tax planning considerations. For example, if you properly set up and fund a trust, you can avoid probate altogether. As I said before, a trust's revocable, it's also amendable. And as long as you are serving as the trustee of your own trust, you have complete authority to make those decisions. You're also in a position to appoint someone to serve as successor trustee for you in the event that you're unable to serve as trustee. That can be during your life if you have a period of incapacity or for whatever reason can't serve. And it would be the person who would serve as trustee after your death. And then one of the things that a trust offers over a will, as I said before, a will does need to go through probate. A trust doesn't. And so it offers you a level of privacy that you wouldn't get from a will. Once a will is filed with the court, it becomes a public document. And if we're going through a whole probate process, there's at least an inventory of your assets that's filed with the court. And all of those things are potentially public documents that people could get access to. So if you have particular concerns about privacy, a trust properly funded is a way to maintain that privacy even after death. But there are disadvantages to trust. Mainly, they can be a little more cumbersome to set up and maintain. As I said, it's important that a trust be properly funded if your goal is to avoid probate. So we need to make sure that when we set up your trust for you, all of your assets are moved into it, or at a minimum, there is some kind of a a TOD designation set up for your assets that would automatically move them to your trust upon death. Because it's more cumbersome to set up, it's also a little more expensive up front. But in terms of balancing costs, you kind of have to think through, all right, a trust is more cumbersome, it costs me now, but it's easier in terms of administration on the back end. And so there are fewer costs on the administrative side of it after your death. And the reverse is essentially true when we talk about using only a will, because a will doesn't require all of the mechanical and logistical effort of funding and all of the time and money that goes into that, but it does require that things go through court. There are court fees and likely probate fees that would be applied. So it sort of depends on which, when do you want the expenses to be incurred is part of the analysis. So as we talk about disadvantages of a trust, if you have assets that are outside of the trust upon your death, it's possible that a probate would still be required in order to move assets. And one primary example of that is real estate that's held outside of Wisconsin. So you may own property in Florida or Arizona, and if it's not owned by your trust, or there's no TOD designation on it that would move it into your trust immediately upon your death, then it's very likely that a probate would be required to move that property into your trust, sort of defeating the whole purpose. So as we mentioned a couple of times, Wisconsin does have default rules for property distribution at your death. It's called intestate succession. This would apply if you do not have a plan. But the question is, do these rules work for you? The way it works is that it passes to your surviving heirs, is generally family. So your property would generally move first to your spouse. If you have no spouse, to your living children. If you have no living children or they have no descendants, then it would move up to your parents, then to your siblings, then up to your grandparents, and then down your grandparents' descendants line. And then if that produces no one eligible to inherit from you, then your property ultimately issues to the state. The intestate succession framework does not allow for distribution to charities. It doesn't allow for unequal distributions. It doesn't allow you to set up perhaps some kind of a financial arrangement for a beneficiary with special needs. Doesn't let you appoint your personal representative or a guardian for minor children. There are a lot of things that people typically like to do with their estate plan when they start thinking it through that are not accommodated by the default rules. And so, again, we would encourage you to think about setting up some kind of an alternative plan to avoid these rules, unless you are absolutely sure that the default and everything that means is okay with you. And I think one example that we can all speak to here is that we have had experience with individuals who have died intestate, and their assets have been distributed to far away relatives, people who didn't even know that they were related to this person. And I'm not kidding, but we're currently working on a probate that distributes to 159 different people across the country, which I'm sure that the decedent was not intending to happen. So please think all of this through and consider whether the default rules work for you. They very well may not. And if they don't, then we need to set up a plan for you.
What will happen if you cannot manage your financial affairs? If you're unable to manage your financial affairs because of mental incapacity and have not given someone else the legal authority to do so, then a loved one will have to go to court to get orders to help you manage your affairs. This can be costly and takes time. In other words, your loved ones cannot help you right away. In order to avoid this situation, it is highly recommended that every adult has a durable power of attorney for finances and property. This is written authorization given by you as the principal to enable another, your agent, to act on your behalf with respect to financial matters. It can be designed to be effective immediately. Even if you are able to manage your own affairs, you can give your agent powers to start helping you right away if you desire. This might be helpful if you either want or need help with your daily affairs all the way up to investment options. Or the document can be designed to be springing. This means that your agent will not have the powers until you are deemed unable to manage your affairs because you are incapacitated. Incapacity means that you are unable to receive and evaluate information effectively, or you are unable to communicate your decisions, rendering you unable to manage your own financial affairs. The scope of this document may be broad or limited. A broad power of attorney grants your agent powers under a multitude of scenarios where they can act on your behalf according to specific directions written in the document. A limited power of attorney can help in specific scenarios where you need someone to act on your behalf, but don't need help outside of that instance. For example, if you are selling your house and cannot be at the closing, your agent could sign documents on your behalf. When choosing an agent with technology these days, the proximity of the person you choose is becoming less and less important. Your agent doesn't necessarily need to be in the same city or even state as you. If someone you are considering naming as your agent is in a bad financial situation themselves or is likely to get into financial trouble for a variety of reasons, then we'd urge you to consider someone else because there might be too much of a conflict of interest. What will happen if you cannot make your healthcare decisions? If you're unable to make your own healthcare decisions, or at least make them effectively and in your own best interest, then healthcare professionals will be left in the dark when it comes to directions for your healthcare. In Wisconsin, without legal authority, loved ones cannot direct a healthcare professional with regards to your health, not even spouses or children. They will once again have to go to court to get guardianship over you so that they can make healthcare decisions on your behalf. Such a court proceeding cannot be done right away. It takes time and it is costly. Having legal documents in place allows your agent to step in and help in real time, therefore getting you the care that you desire as you need it. To accomplish this, every adult should have a power of attorney for healthcare. This is written authorization given by you as the principal to enable another, your agent, to act on your behalf with respect to healthcare decisions. It is effective when activated by a physician after their determination of your incapacity, meaning you are unable to manage your own healthcare decisions. There is also another document called a living will. This document provides direction to healthcare professionals and your agent regarding your wishes to withhold or withdraw life-sustaining procedures or feeding tubes if death is imminent. This document is informative to your agent and is frequently completed in conjunction with the power of attorney for healthcare. Do the parts of your estate plan work well together? Will my healthcare agent, financial agent, successor trustee, and personal representative work well together? Not only that, but are these people trustworthy, and do they know your wishes with respect to their respective roles in your life and estate plan? They're handling very sensitive areas of your life. While you can only name one person at a time to act as your healthcare agent, you can have 2 or more people acting as co-agents in other roles. We'd caution you against naming co-agents though. Before making that decision, you should consider the likelihood of the co-agent's ability to actually work together. Despite your best intentions, the people you name might have a difficult time working together, thereby making the process inefficient. It is important for any co-agents, as well as people named in the other various roles, to work well together because in order to carry out your desires and administer your estate, they will frequently interact. But in some instances, the same person could fill all of these roles if you so desire. Have I funded my living trust? In order for your trust-based estate plan to work as intended, as Rachel said, including avoiding probate, all assets that you intend to be assets of the trust need to be retitled or transferred accordingly. It is easy to miss an asset or purchase an asset later and forget to put it into the trust. It is very important to be diligent about record keeping and being aware of how assets are titled. Reviewing your list of assets frequently is key. Do my beneficiary designations for retirement accounts, POD accounts, and life insurance support or contradict my estate plan? Assets that have beneficiary designations are extremely important to implementing your estate plan after you're gone, yet they are frequently overlooked. When you are setting up your estate plan with your attorney, you will also review your list of assets with such designations. If the beneficiaries are not already consistent with your plan, you will need to update them to reflect your plan. If a beneficiary designation is not set up properly, such a mistake can undo what you and your attorney spent time and money setting up. Also, if your designations are not completed or are outdated, then assets could end up going to someone no longer in your life or to someone who should not inherit outright because of their age or disability status. Also, look out for convenience accounts, which are financial accounts that you give another individual access to for the sole reason of convenience, so that they can help you manage your financial affairs. These accounts are dangerous and can mess up your estate plan. By establishing these accounts, you can unintentionally create joint ownership when all you intended was for that person to act as your agent. Creating a power of attorney and giving your agent access to your account as your power of attorney rather than as an owner can provide you with the help you need. Should I write a letter of last instruction? Some people choose to create this optional document, which can designate someone to arrange your funeral or memorial service or carry out your wishes with respect to your body after your death. You can make this document as detailed as you wish. If you're going to prepare one, though, make sure it is with your will and make sure your agents are aware of it so that it's not found well after your funeral or other services are done. How frequently should you review your estate plan? The accepted rule of thumb is every 3 to 5 years, but as you age, that rule of thumb gets smaller and smaller. Reviewing your plan this frequently will help catch changes in laws applicable to your plan and helps you make adjustments to your plan as your life changes or the lives of loved ones change. Perhaps you want to change one of your agents or no longer want to make a cash bequest to your friend or a charity. Perhaps you lost a loved one previously designated as a beneficiary of your plan. What can happen to me or to my spouse if our plans are outdated or are never created? Long story short, not creating an estate plan or not reviewing your estate plan and periodically revising it to reflect your current life situation and goals can be very costly. Not creating a power of attorney documents can later generate high court fees for guardianship. Not designating a guardian for your minor children can lead to an unwanted caretaker for your children. Not getting all of your assets into your revocable trust can cause your estate to go through the probate process even though you put in so much work to avoid it. Despite the rule of thumb, you are always welcome to update your plan more frequently as things come up.
Oh, Johanna, you're muted.
I'm so sorry. I did not realize I was continuing to be muted. Sorry about that. So I am here to talk about whether or not and how to consider charitable giving as part of your overall estate plan. Another name for charitable giving is also plan giving. And the reason why it's called plan giving is because charitable giving or plan giving tends to take a little more time and thought that's somewhat independent of your estate plan, but very ultimately interwoven with your estate plan. So it takes a little more effort for many of these types of charitable gifts you might want to make. So there are certainly many non-financial reasons for including charitable giving in your planning. One is to pay your good luck forward. It provides you with an emotional uplift after you've made a gift or planned for a gift to occur after you pass. It also creates a culture of collaboration and community involvement. And we see that with our library and how wonderful a place, a community center that has become. And it couldn't be the way it is today without charitable gifts and both time and money that people of our community have given to the library. And also it's very often quite needed by the recipient. So you can do quite a bit of good. So those are some ways to think about why you might want to involve or have charitable gifting involved in your estate plan. Also, it helps you leave a legacy. If there were things that were important to you, causes that were important to you during your lifetime, you can, with plan giving or charitable giving, create a legacy by supporting those causes after your death, and certainly while you're alive. So some financial reasons to include charitable giving is tax planning. That if you give to charity during life, you will receive an income tax deduction, or it may reduce your reportable income. And giving to charity through your estate plan after your death gives you an estate tax deduction. And it also, you can set it up in a way to benefit some of your beneficiaries with charities receiving. So there's different types of tools that can be put into play, actually for both giving while you're alive and giving after your death, that would create tax benefits for you or your estate. Okay, so ways to give during your lifetime. Well, certainly gifts of appreciated stock or real estate would be good, but also cash is good and can be immediately deployed by the recipient. Last year, 2021, the Charitable Care Act allowed for people who made cash gifts to certain qualified charities, the library of which would be one, were allowed to deduct that cash gift up to 100% of their adjusted gross income. I haven't seen that that has been applied to 2022, and I haven't really heard any discussion about that. It was started in 2020 and carried over to 2021, and so I don't know if they're going to do it for 2022. But if they do not, cash can be deducted up to 60% of your adjusted gross income. Appreciated stock or real estate would be limited to 30% of your adjusted gross income. But if you give to a donor advised fund, then it's 50% of your adjusted gross income. Then there's always a 5-year carry over for amounts that you have given, but you were not able to deduct in the year of the gift. And then there's the qualified charitable distribution, and those are for donors who are at least 72 years of age and required to withdraw a required minimum distribution from retirement accounts. This type of tool allows you to, instead from receiving those required minimum distributions, you can direct that those RMDs, or even up to $100,000 a year from your retirement account to charity. And then all amounts rolled over to charity would not be reported to you on your Form 1099-R. So it gets excluded from your reportable income. Okay, and then ways to gift through your estate plan. There's many different types of tools that could be deployed. And this being that it's a rather basic estate planning class, it's not necessarily, or it's beyond the scope of this class, and we could do another one if people were more interested that would get deeper, do a deeper dive into this. But some easy ways to make gifts through your estate plan is by designating beneficiaries. So using your ability to designate beneficiaries to include charities. So you would designate a charity as part of your beneficiaries of your life insurance, for example. You could always also do that with your tax deferred retirement benefits. So this would be something different than the qualified charitable distribution. It'd be having the charity be designated to own either all or a portion of that account upon your death. And both the life insurance and the tax deferred retirement benefit designations are very beneficial in that they provide estate deductions if your estate is taxable, but it also allows you to not have to give up assets while you're alive. So if you are in a situation where you're living on a defined amount month to month, and either through a combination of Social Security and retirement benefits, you can set this up to be effective after you die so that you benefit others, but you're not necessarily reducing the quality of your life. And then also outright distributions of property. And this would be done through your will or your trust agreement, because as Rachel mentioned before, without a will or trust agreement, you are not able to make distributions on your death to charity, because you would be limited to those distributions that were set forth in the laws of intestate succession. So those are just a few things to think about in terms of charitable giving.
And I would just add, Johanna, that if you're doing planned giving and you know which entities you want to give things to, it's probably a good idea to consult with that organization, because many have policies about the kinds of property that they're willing to accept.
That's a good point, and wholeheartedly agree with that. You may find that they're not able to do what you would want to have be done with the property. So it's good to have that discussion in advance. So some tips for getting started. I guess if you have a plan, it's good to know the age of it. If you faintly remember that you did it, but you don't know where it is, it's probably a good time to get started on doing another plan. Collect information on your assets, debts, income needs, and beneficiary designations. And then think about who you would like to appoint as financial agent, healthcare agent, personal representative, successor trustee, and if necessary, guardian for your minor children. These are all roles that we've talked about with you previously today, but these are things that you can think about. Who might be good to serve in what role? And then also think about your distribution goals and your intended beneficiaries. Think about what they might receive. Will they use what they receive in the way that you hope that they would use it? Will receiving create a problem for them, either because they are on disability benefits or means tested benefits, and receiving an inheritance might prevent them from actually continuing on with their benefits? Or are they in a situation where they're not managing their money properly or something to that effect? There's drug problems, things like that. Start identifying all of those unique characteristics of the people that you would like to be recipients of your estate. And I would even go so far as to write some of these things down so that you don't forget, because those will all be important when you meet with the attorney to start talking about your plan and what tools would be good to include in your plan. And then please keep in mind the importance of renewals and the scope of your current plan. Now, I always advise people when they first get started to plan as if you are going to die tomorrow, knowing that that's not likely to occur. And then just promise yourself that you will have the plan periodically renewed. And at our office, we send out reminder letters saying that we met with you on today's date 3 years ago. It's you indicated you wanted to be reminded after 3 years. It's been 3 years. Please let us know if you're interested. So just as kind of a way to keep it on people's radar, and also keeps the plan on our radar as well. So, and I think that not only it helps keep the plan current, but it also helps you from trying to envision what life might be like 15, 20, 30 years from now, and which is an extremely difficult task, and sometimes can result in somebody coming to a halt on moving forward with their plan simply because the scope has now gotten way too large for any one person to try to accurately predict. And then, as I mentioned, and identify any family issues or special needs that could be relevant to your plan. So all of things will be very, very helpful for the attorney to know. Okay, so then what to expect? Well, each firm handles things a little bit differently, but what I've got here are a list of things I think in general you would find, depending upon the type of the type of attorney you're working with, and what you're asking them to do. So first, you should receive a call back within a relatively short period of time after you place an initial call to the attorney. I know how difficult it is to make that initial call, or how difficult it could be. Most people aren't in the habit of picking up a phone and calling an attorney. And so that's kind of a hard threshold to go over. And you should receive a call back that should be respected. You'll likely be asked to provide the attorney with specific information about your family, assets, and goals. And that's why it's good to kind of get prepared for those types of questions. And you can and you should ask about fees, but keep in mind that you may not receive a full answer until the attorney knows more about your goals and special circumstances, because all of those could play into what type of plan would be best for you to consider. And most of us are hourly keepers, so that we keep track of our fees based on how much time we spend. So they should be able to estimate after they hear more from you about the ballpark of what the fees might be. And I think it's good to have that discussion early on so that nobody is surprised. And then the attorney should prepare drafts for you to review on your own and with the attorney. And please let them know if you see edits that should be made and if you have any questions. And then also, and finally, please let the attorney know if you're happy, or alternatively, if you see things that need to be improved with the process. Your feedback is important. And if you feel that things are not going the way that you would like them to go, please let the attorney know as soon as you can, so that the ship can be righted, so to speak, if it's gone south. So those are all things to keep in mind when you're dealing with your attorney, and what to expect, and when you reach out to a law firm to get some help with your estate plan. So that's our presentation, and I understand there's been some questions that have been recorded.
There have. Thank you all for that presentation. That was a wonderful basic overview, and I absolutely learned some things myself. We have about 7 or so questions, and they're actually all really, really pertinent, and I think complement the subject matter you covered today. So I'm just going to dive in, and whoever wants to answer can go ahead. The first one we got prior to the presentation today: once your children become adults, so turn 18, do parents still have healthcare and financial power of attorney rights for those adult children, or does that child need to have their own estate planning documents for parents to make those decisions?
Why don't I start with answering questions? The answer is they will need their own documentation: powers of attorney for health, powers of attorney for finances and property. And the reason being is just that they're 18, and their right to privacy is very much front and center. So the power of attorney for healthcare will help. And also there's another document called authorization for release of your protected information. And it's allows the people on that form to talk to the doctors or other healthcare providers on their behalf. So power of attorney for healthcare is good because it allows you, if you're the parent and they want you to continue to make healthcare decisions for them if they were not able to. And then the authorization is a good partner to that, because it allows you to talk to healthcare providers and get information that could be useful to you.
Okay, great thoughts. Thank you. We touched up on this a little while at the early part of the presentation, but I do want to revisit it just because it was asked. What happens when a will provision and a transfer on death document differ over the same asset?
The transfer on death takes precedence. So that's why it's very good when you're planning those types of probate saving devices to make sure that you've got the entire estate plan in mind. And because it's very easy to thwart the plan, or this sounds very harsh, but bankrupt the plan, and that you may have certain assets going according to what your will says. But if you TOD or POD is sometimes what it's called, say an account that you've been using to pay expenses, for example, a house that's part of your estate, there might be nothing to pay the bills. And the people that you've designated to be beneficiaries of that account may or may not be open to sharing that money with the estate. So.
Okay. Can spouses create one trust, or do they need to have separate trusts individually?
In Wisconsin, they very often create one. If you have property that's individual and you are intent on keeping it individual, sometimes a separate trust would be good because it's, I guess, cleanly keeps it separate. But that's also not an absolute necessity either. We can define it as separate based on the trust agreement, and also how you manage those accounts after they're retitled in the name of the trust.
Okay. I'm gonna skip to a later question because this is a thought that I've had also. We talk a lot about how like the state laws guide how this process works and how we should think about property. Does it vary at all on a county by county basis as far as probate and legal requirements of those sorts of things? Or if you're in Wisconsin, are you all under the same jurisdiction, I guess?
So the laws are the same, but the manner in which they're, I guess the manner in which the probate is handled can be different on a county to county basis. Some counties, because they have so many people going through the various processes, whether it be probate or guardianship or any of the others, administrative type processes, or they have a more formal way of handling things. And that's just the way, it's good to know what the county's preferences are so that you're not having to redo work, or going down a path that shouldn't be entered. As an example, say in Iowa County, Sauk County, they require a final account to be submitted and filed actually with the probate registrar once the estate is ready to be closed. The probate administration is ready to be closed. Whereas in Dane County, they require you to do it, but you can display it. You don't need to file it with the court. So that's just one example, but there's others. It used to be, I'm going off a tangent here, but they used to be that some of the counties required certain colored paper when you were filing. Others did not. And so now that it's all electronic filing, thankfully those nuanced rules have gone away, but still, that's shows you the level of change that could, or difference that could happen. So,
yeah. Well, I think one of the overarching things I'm hearing is you want to eliminate surprises on all ends. So good to know how things work where you're at specifically. This is another question that I'm sure you covered earlier, but because it was asked, I want to make sure this participant has it answered. Why do people have their homes titled to the Revocable Living Trust? Like, why is the house, like when you purchase a house and you set up a trust, why do you retitle it in the name of the trust?
Well, it avoids probate on your death if you still own the home when you die. It helps with successive management. So if you want to stay in your home, but your ability to manage your affairs has become compromised for whatever reason, then your successor trustees can help you manage that home, as they will be able to do with any asset you have titled in the name of the trust. Sometimes people will keep the name of the house in their name, but have it be transfer on death to the trust. That's another way to avoid probate. I guess it's up to you in terms of your comfort level. The advantage is it helps to avoid probate. It's very clean. You've got a successive management already in place through the trust agreement. I guess a disadvantage would be that when you go to sell the house, if it's titled in the name of the trust, very often their title company will want assurance that you as trustee of the trust have the ability to sell it. And so various parts of your trust agreement may need to be provided to the title company to confirm that you have those powers, you are in that role and have the ability to sell the house from the trust. So.
Okay. Question regarding power of attorney for healthcare, which you guys covered earlier. Does the power of attorney document need to be filed with every healthcare provider you might work with over time, or does it just need to be filed once? Do you guys have any insight into that?
Yeah, I guess some of this is anecdotal. That my experience is that, and that those of clients we've worked with have been that you take it to your primary care provider and have them upload it as part of your electronic file. And that will allow for any of the providers that have access to that system to look at that form. If you go outside of the system and perhaps even outside of the clinic, I think I would be prepared to provide your power of attorney for healthcare, particularly if you're going to be having surgery of some sort or having a procedure where the power of attorney designation will be important for you. I would that would be a call I would place before I got to the hospital or to the surgery center, just because if you don't have it and they want it, then they may present to you a blank form. And then you would, in the interest of just moving things forward, because there's so much else on your plate for that day, fill it out. And it may name people other than what you remembered, so I guess rather than having more and more of these forms out there, I would just make sure that it's in your primary care through that system and then bring it with you to other places.
That makes total sense. Thank you. Most of my friends are in the same age range, and I'm afraid they'll predecease me or not long survive me. I don't have near relatives. I don't want this circumstance where the state is hunting for distant relatives. This individual wants to leave most of their estate to charity. How should they go about this, knowing that they're not sure who they would utilize as a personal representative?
Well, I think I would look to professional personal representatives or professionals that are in this arena, so to speak, to serve in that role. There are trust companies in town that have people that do this type of service for others all day, every day. So they're very skilled at what they do. Sometimes the attorney helping you will serve in that role. So I guess I would look to having a professional person serve, because then you'll know they're held to higher standards, and they have a body of knowledge, institutional knowledge in dealing with the estate.
Okay, good to know that resource is available. I'm sure that this person is not alone in that circumstance.
No, very common.
I'm very curious about your thoughts on this question. Is using a tool like free will advisable or even legal?
Okay. So I think it's tough. And we've probated estates that were based on the legal Zoom or free will, things that you get off the internet. And very often they didn't contemplate the complexities of their life when they use that. And I mean, it's your life. You realize it's complicated because it's your life and you live it every day. But from a legal perspective, it could have that. And it really, it's very similar to the laws of intestate succession. It's that it's hard to know what should be taken into account to make sure that your goals are met if you're using something that's sort of prescribed. And so I would pay the money and go get this done by a professional, because otherwise you're likely to pay, or your beneficiaries will pay after you die. It'll be a more complicated process.
Yeah, we've certainly seen that in the variety of examples you've shared today, all the different considerations that you have to make there. We're at 12:58. I'm going to skim the last couple questions. Oh, interesting. So the medical incapacity process is pretty easy to wrap your brain around. How would financial incapacity be determined or weighed?
Well, you can define it different ways in the durable power of attorney for financial or for finances and property. You can tie it directly to the healthcare incapacity standard, in which case then both would be activated when the healthcare power of attorney was activated. Or you could put together, unable to manage my financial affairs, and then have a person or your physician make that call based on interviewing people in your life. I've also seen it where there was a committee of people, of friends, that decided that this was happening and we needed to activate this so we could help this person. So there is some flexibility, and it depends on what your comfort level is and the type of assets that you own too. What might be best. So I know we're running out of time and we have more questions, but so just let me say, if you have any other questions, we'd be happy to entertain them. We really would. And you've got our contact information. So please feel free to reach out to us if your question, was submitted, but not answered. So sorry about that.
No, a lot of good questions today, and I love an engaged audience. So thank you for your time and in preparing everything that you did and answering to those rapid fires afterwards. So everybody, thank you on behalf of the Madison Public Library Foundation. Thank you to our presenters for sharing their time and expertise today. They have been kind enough to share a PDF of their PowerPoint slides from today, and we will share that with participants via email shortly. It was recorded, and we will post the recording on our website within the week. You'll all get an email with a link to that recording once it's available, and do feel free to share it with whomever you think would benefit from this information. We'll also ask all of you to complete a brief survey about this event. It's very helpful to us in planning for future sessions and to hear what worked well and what didn't. Please look for that in email as well. And yeah, finally, thanks again to everyone for joining us today. Thank you again to our presenters, and thanks for your interest in the Madison Public Library Foundation.